Good morning, everyone. Thank you so much for being here. We'll just give everyone another minute to settle in and then we'll get started. Good morning, everyone. Welcome to the 41st installation of the Panage Training Academy. Today, we will be giving an IP case law update about the most important patent, trademark, copyright, and even a trade secret case within this past year. My name is Julianna Hunt, and I am a second-year associate here at Panage Shoresy. I have a background in chemistry and the chemical sciences, and I handled both patent prosecution matters as well as patent, trademark, copyright litigation matters. Joining me today is my colleague Keith Jones, and I'll now turn things over to Keith for his introduction.
Thanks, Juliana. Good morning, everyone. As she said, my name is Keith Jones. I'm counsel here at the firm. I've been doing IP litigation for about 15 years now, so this topic is right in my wheelhouse. Before we get started, just a reminder that this session is being recorded and will be available on our website by the end of the day tomorrow. Feel free to submit any questions in the chat or the Q&A feature. We'll be keeping an eye on both of them throughout. If you are seeking CLE credits in Delaware, Georgia, North Carolina, Pennsylvania, or Virginia, please stay for the full session, respond to both pop-up polls, and complete the feedback survey at the end. And with that, let's get started. All right, we're going to start with our trademark cases. Real quick to start, I wanted to give an update on a case that we covered last year. Just as some background, there was a trademark infringement case between Dewberry Engineers and Dewberry Group that went to the Supreme Court. And the specific issue was that the plaintiff sought and was awarded um, disgorgement of profits against all of the defendant's affiliated companies. The defendant was basically a holding company um, that didn't have any profits. All the profits stayed with the subsidiary companies. So the court awarded disgorgement of all those subsidiary companies' profits. That issue went to the Supreme Court, and the Supreme Court said no, under the Lanham Act, defendant means defendant. Um, but Justice Sotomayor concurred and pretty strongly hinted that maybe there's another way you can get those profits. Um, and so it went back down to the Fourth Circuit, and there's a couple different theories that the plaintiff was using to try and get those profits. The statute has a just sum provision that allows the court to adjust the award up or down from the actual numbers. So that's one way that the plaintiff is trying to capture those profits. There's another theory that's less grounded in the statute that is just a let's look at the reality of the situation um, and find their true financial gains. The lack of profits essentially was a on paper lack of profits and not a realistic one. And then they argued also that maybe corporate veil piercing could apply. Um, the case is now back at the Fourth Circuit. It was going to be argued last week, but then the court um, continued it, and last I checked, there was no oral argument date set. Um, so I wanted to just highlight that. I will probably put out a little blog post when we finally get an answer on this. It's an interesting question about how to try and get your damages in a trademark case. But while we wait for the answer, I think the practical pointer is to just name all the defendants. Don't just name the parent company. And that way they are proper defendants in the suit and you can get their loss, you can get their profits disgorged.
Thanks, Keith. All right, turning to our second trademark case. So this is Fuente versus Vaporous Technologies. So Fuente is a Dominican cigar company which owns two standard character federal trademark registrations for the letter X, which is used on its cigars, ashtrays, cigar cutters, lighters, specifically in connection with its Opus X brand. And Vaporous Technologies filed a trademark application for a stylized design depicting an abstract X stick figure with a shaded circle above it. And I'll show you a side-by-side comparison on the next slide. But they filed this trademark application for use in connection with its oral vaporizer products, specifically its Dab X Dab Rig Concentrate Vaporizer product. So here's a side-by-side. As you can see on the left is the Fuente Opus X brand, and you can see the standard character X there. And then on the right-hand side is the abstract stick figure X used with Vaporis's technology and its Dab X brand. So Fuente opposed the registration of Vaporis's mark under Section 2D of the Lanham Act, alleging a likelihood of confusion with its X marks. And the TTAB ultimately dismissed this opposition in December 2023, finding no likelihood of confusion. And not surprisingly, Fuente appealed to the Federal Circuit, challenging the board's decision with respect to DuPont factors 1 and 5. I'll show you a slide on the next page of the DuPont factors, but for those of you who don't know, these are a set of 13 criteria which are used by the USPTO as well as federal courts to determine the likelihood of confusion between two marks. So here, the only two at issue were the DuPont factor 1, which is similarity of the marks, and DuPont factor 5, which is fame or strength of the prior or the senior user's mark. So here, the Fuente standard X character marks. And probably the first two, DuPont factors 1 and 2, the similarity of the marks and the similarity of the goods and services, are the most important. With respect to DuPont factor 1, this really assesses the similarity of the marks in their entireties. So the court and the board will consider things like the appearance, the sound, the connotation, and even the commercial expression of the marks, ultimately to determine whether or not consumers would assume a connection between the parties of the respective marks. And then DuPont factor 5 is a little bit less important, but it essentially considers the fame of the senior user's mark. And fame has been described as a matter of degree, which varies along a spectrum from very strong to very weak, and considers things like sales, advertising, length of use of the mark, market share, and brand awareness. So ultimately, the legal issue before the Federal Circuit was whether the TTAB here had properly concluded that there would be no likelihood of confusion where consumers perceive that Vaporous, the abstract mark with the circle above it, whether that would have no confusion, a lack of confusion with respect to the Fuente character mark. And so the Federal Circuit affirmed and dismissed the opposition, finding no likelihood of confusion. And here, the decision really was dispositive after just the single factor alone, the very first DuPont factor number 1. So this case really reinforces the fact that even a single factor could be dispositive, especially if it's one of those first two factors, similarities of the mark or similarity of the goods and services. Essentially here, the court found that consumers would perceive the mark as a stick figure and not the letter X, even if there were overlapping channels of trade here. So especially like the oral vaporizer and the cigars are similar channels of trade. With respect to factor 5, the court addressed it, but ultimately found it neutral, saying that the Fuente's mark was arbitrary with respect to cigars, but it lacked, making it conceptually strong. But it had weak commercial strength because consumers would not independently consider the letter X on its own as a source indicator for Fuente and its Opus X brands. So again, just in terms of practical pointers, similarity or dissimilarity of the marks so that DuPont factor 1 can ultimately carry the day. And just a second pointer is that conceptual strength alone does not give a mark more protection, especially if it doesn't have that commercial strength as well.
Moving on to the next one, we have a third trademark case. It's currently pending in the Third Circuit. It's Penn State versus Vintage Brands. And the gist of it is that Penn State sued Vintage Brands for trademark infringement because Vintage Brands sells t-shirts, hats, etc., with the words Penn State and also with some very old Penn State logos. And I think that they chose old ones to get around copyright issues. Penn State alleged trademark infringement. You can see some pictures here below. Um, with no context, you probably can't tell which ones come from Penn State authorized sources and which ones come from Vintage Brands. It's the one in the middle of each row that is the defendant's product. Um, Move to the next slide. Here we go. It went to the district court, um, and the district court did a couple of things. Before trial, it granted summary judgment for the defendants on the claims of counterfeiting and dilution by blurring. But it allowed the kind of meat and potatoes trademark infringement claim to go to the jury. Jury found for Penn State, also found willful infringement, and both sides appealed. Penn State appealed the dismissal of the counterfeiting and dilution claims because counterfeiting in particular allows you to get statutory damages, and also it would have given them a much better chance of getting attorney's fees awarded. Vintage Brands appeals because they obviously don't want to be found liable for infringement. Um, the two issues for Penn State is that the district court found that for counterfeiting, uh, it only applied to claims where people would be confused about the manufacturing origin, rather than more broadly sponsorship or approval that is otherwise protected by the Lanham Act. Um, there's really no dispute here that anyone thought that the defendant was, um, you know, acting as if Penn State made the products. They always held themselves out as independent. And so with that narrow framing of counterfeiting, there was really no contest. As far as dilution, the idea of dilution is that two overly similar marks being in the marketplace um, will weaken the strength of the plaintiff's mark. Um, the district court ruled strictly based on um, an essentially the same um, threshold in terms of whether the marks were essentially the same as each other. Um, Penn State argues that the Trademark Dilution Revision Act of 2006 got rid of that standard. And so basically, they think that the district court just applied the wrong legal standard. As I said, this case is pending, so we don't have an answer on those issues yet. But likewise, if we go to the next slide, the defendant wants to appeal. And they want to appeal not because they don't think that there's a likelihood of confusion, because as you saw on the first slide, that the words Penn State are the same regardless of whether the plaintiff or the defendant uses them, and they admittedly copied some of the old logos. What they actually want to say, though, is that the use of those words and logos is functional. It's not meant to identify the products as coming from Penn State, but rather that people use them as a form of expression to say, "Hey, I went to Penn State," or "I'm a fan of Penn State football," or some other way of saying, "I like Penn State." As if you were to have a T-shirt with a turtle on it just because you like turtles. Um, and so that's their argument. They cite to a 1982 Third Circuit case, which essentially said that should be the standard, and that for universities in particular, it is functional. But interestingly, once the Third Circuit made that ruling, but I guess before the mandate issued, the parties settled it and agreed to a consent decree that vacated the decision. Um, it's sort of news to me that parties can unilaterally agree that a court decision goes away. You would think the court would want their decision to stand. But vintage brand is basically saying you ruled this way once before. It went away for a silly reason, but you should rule this way again. Um, if we go to the next slide, there's also three groups of amici that have weighed in. Um, two of them on the side of Penn State and one of them on the side of the defendant, which I find fairly interesting. One of them, Society of Product Licensors, said that applying counterfeiting in this overly narrow way would cause a huge problem for Customs and Border Patrol. If you're not aware, you can register your trademarks with Customs and Border Control, and they will inspect products that are being imported into the country, look at the logos and the names and the trademarks that are on them, and they compare them against the list. And if they find that there's infringement, they can just pull those products and keep them from going to wherever they're supposed to be delivered to. So it's a very powerful tool for a trademark owner, particularly in counterfeiting situations. Um, but the Amici's argument here is that if you apply it this narrowly, um, it would just completely undercut Border Patrol's customs ability to do that. Um, Penn State also has support from the Intellectual Property Owners Association, um, which was a little bit more of a high level. It wasn't targeted specifically on that one practical issue, but they basically said that there's no reason to prohibit a licensor of a trademark, like Penn State here, from asserting counterfeiting. Basically, you shouldn't have to manufacture the product yourself um, to be able to stop counterfeiting. And they backed up Penn State's position that the dilution standard changed in that 2006 statute, and said that the similarity is just a factor. It's not the dispositive issue. On the other side, there's 25 trademark law professors, um, sort of all collectively represented by the Stanford Jules Gard IP Clinic, um, that basically reiterated kind of what the defendant was saying, in that people who have these university t-shirts and hats and things are expressing their support for that. It's an expressive use, and it's not a source identifier. And so you shouldn't use the traditional trademark infringement factors to measure that. And in the Third Circuit, they're the lap factors. They're basically the same as the DuPont factors that Juliana just talked about. Um, and so that they're urging an infringement test for universities and other cultural institutions, that draws more from nominative fair use principles and aesthetic functionality. That was an interesting case. I sort of find myself agreeing with the positions that everyone has taken. Um, and I hate to say that the hardworking district judge got everything wrong, but I sort of feel that way. I think both sides raised some really interesting issues, and I'm going to be curious to follow along with this one and see how the appeals court comes out.
Thanks, Keith. That's definitely sounds interesting. So that was the end of our trademark case law update. So we're just going to transition now into patents. And I have a brief update. Last year, for those of you who joined us, we covered the Ameren versus Hikma case. At the time, it was a Federal Circuit case. And right now, actually, it's before the Supreme Court. Supreme Court granted cert in January of this year and recently heard oral arguments actually a couple weeks ago, back on April 29th. We can expect a final decision by the end of the Supreme Court's current term, so hopefully sometime within, the next month, June of this year. But for those of you who don't recall, this case is a Hatch-Waxman case in which the generic manufacturer Hikma here filed an ANDA with the FDA, as well as a Section 8 statement seeking approval for its generic form of the brand name drug, which is marketed and manufactured by Amarin. The brand name drug is called Vascepa, and it's for treating severe hypertriglyceridemia, which I'll just refer to as SH, as well as it has some other cardiovascular indications as well. So here, Amarin, the brand name manufacturer, sued Hikma on a theory of induced patent infringement under Section 271B of the Patent Act, basically asserting that even though Hikma had fully carved out the patented use from its skinny label, Hikma was engaging in other conduct, such as, they looked at their press releases, public statements, and really just statements to the brand name drug Vascepa. And Amarin alleged here that Hikma is actively encouraging use of its generic drug for the off-label patented uses based on the theory of induced infringement. So at the district court found no induced infringement. And then, of course, last year we covered that the Federal Circuit had reversed this and really a groundbreaking decision, finding that Amarin had sufficiently pled induced infringement by Hikma here by encouraging and instructing others to use the generic form of the drug for a patented use. And I just wanted to point out that the United States has filed an amicus brief in support of Hikma here, so in support of the generic manufacturer. So kind of as stated previously, there's really two main legal questions presented for review, but I think it's important here to just remember that at this stage in the proceeding, it's just about the pleadings. So this is really a Rule 12 motion to dismiss. So the court's really just determining whether or not Amarin has sufficiently, made out a plausible claim of induced infringement here. So the legal question is really just, when a generic drug manufacturer fully carves out a patented use are its allegations that it calls its product a generic version and whether it cites certain public information about the branded drug, such as sales, or even just calling itself the brand version of Vascepa, whether that is enough for induced infringement, or at least to make out a claim for induced infringement, even if there's no evidence, hard evidence of actively encouraging or instructing use of the brand name drug. Obviously, this case has a lot of very important implications, especially for generic manufacturers, but also just pharmaceutical IP in general. Um, Unfortunately, if affirmed, we could certainly see down the road a decrease in generic products on the market as more and more generic drug manufacturers probably will be deterred from, availing themselves of this framework and the Hatch-Waxman and the ANDA Section 8 pathway, especially if they can face, liability for induced patent infringement. But it really will have some substantial implications. And as Keith mentioned earlier, I certainly will put out a blog post whenever we have a final decision from the Supreme Court about this issue.
Next case is range of motion products versus Armade. This is a design patent infringement case. Um, it's for a patent titled body massaging apparatus, but as you might guess from the defendant being named Armade, it's a device you can kind of stick your arm in there and it'll massage your arm. Um, the core issue comes down to whether certain features of the claim design are functional or ornamental and how that distinction affects the claim scope for infringement purposes. Um, for those of you who don't know, with design patents, you're only protecting the ornamental features of the design. And so if a part of the design is functional, that's not protected by the patent. So here, the district court granted summary judgment of non-infringement because it construed the claim design as having several functional features which it had to exclude from protection. Range of motion appealed. If we go to the next slide, we have some images which should help people see. Oh, here we go. We got a poll for CLE credit. So everyone click that. The picture on the left is the picture from the patent. It shows the design. In design patents, features with dashed lines are shown just for context. They're the functional parts that are not claimed. So you can see those little the roller parts right in the middle. It's a little hard to see with the size, but they are dashed because they are obviously the part that massages your arm, and so they're functional. The rest of it, though, was done in solid lines, which meant that's what they were trying to claim. You can see in the middle, that is Range of Motion's actual product. It looks very much like the drawing from the patent. And then on the right is Armade's accused device. It's got a pretty similar design. Some differences like the size of the balls on the massager are a little different. One thing that got focused on in the briefings is down the bottom, the size of the sort of rectangular or oval part that kind of holds the one arm in place is much bigger on Armade's design. But you can see that they look fairly similar. Um, so if we go to the next page slide, um, the Federal Circuit decision came out a few months ago. It's a 2-1 split decision. The majority affirmed, and they found that the shape of the arms is functional and not ornamental, despite how it was drawn in the patent, based on evidence that we got introduced in discovery that showed the shape of the arms functions to manipulate the amount of pressure you get in the massage. So therefore, it was proper for the district court to exclude that from claim scope. Um, and Because of that, we can draw from that, even if someone draws it in solid lines in the drawings, you don't need to consider that. That's not dispositive, and you don't even need to consider it as purely ornamental or purely functional. It seems like there's a little bit of a sliding scale there. Um, but what makes this interesting is that Chief Judge Moore wrote a pretty strong dissent that I personally found pretty compelling. Um, she said, firstly, she would have allowed the jury to decide the infringement because it's a fact issue. Um, but secondly, and what makes this case more interesting, uh, she pointed to, I believe it's a Supreme Court case that sets design patent standards. And she pointed out that Supreme Court talks about whether designs are substantially similar, um, but the Federal Circuit and district courts have since then started to analyze whether things are sufficiently distinct or plainly dissimilar. She says that essentially everyone's applying the wrong standard, and that you need to do a more holistic, do these two things look substantially similar or not? I thought that was a, a pretty compelling dissent, and range of motion obviously picked up on it and petitioned for an en banc review. Um, Several amici have joined in with their support, and I believe the Federal Circuit has invited a response from Armade, which shows that they're taking it fairly seriously. So I would not be surprised if we see a full en banc review, which these days is pretty rare from the Federal Circuit. So it'll be interesting to track that one too. But while we wait for the decision, um, for everyone prosecuting design patents, be very clear in your drawings what you consider ornamental and what you consider functional. And while you're litigating, just to make sure you stay on the right side of things, focus on the similarities between the products and not the differences.
All right, heading into our next patent case here. This case is GoTV streaming versus Netflix. So GoTV owns 3 U.S. patents, all directed to methods and systems for delivering and tailoring server content for streaming on wireless devices based on device capability. So things like screen size, resolution, and processing power. GoTV sued Netflix, asserting both direct and induced patent infringement. And Netflix moved for judgment on the pleadings, arguing that each of the 3 asserted GoTV patents are directed to ineligible subject matter, specifically an abstract idea of a generic template of specifications, which is specifically and personally tailored to the user's device constraints. So Netflix moved here for judgment on the pleadings, alleging invalidity under Section 101 of the Patent Act. The district court, first and foremost, dismissed the claim of induced infringement against Netflix for lack of pre-suit knowledge. And with respect to direct infringement, the district court rejected Netflix's 101 challenge, but held that all of the asserted claims of one of the 3 patents was indefinite under Section 112. However, with respect to the 2 remaining GoTV patents, a jury found that Netflix had directly infringed. those two remaining patents and awarded 2.5 million in damages. Both GoTV and Netflix filed certain cross appeals on both claim indefiniteness as well as patent eligibility under Section 101. So the legal issue here is pretty straightforward, just with respect to the 101 issue on its own, is whether claims directed to server implemented tailoring of content delivery to a specific user's wireless device capabilities, whether that is patent eligible or ineligible under Section 101. So the Federal Circuit here reversed the district court's judgment with respect to patentability of the three GoTV patents, ruling in favor of Netflix and finding that all of the patents were ineligible under Section 101. So for those of you who are familiar with the Alice test, it's a very, traditional two-step framework that the court applies to determine whether or not claims are directed to patent eligible subject matter under Section 101. So for step one, I'll go to the next slide, which outlines the test nicely. The first kind of baseline threshold question is whether the claims are directed first and foremost to a process, machine, manufacture, or composition of matter. Obviously here the answer was yes. And progressing to step 2A, I guess, of the Alice test is whether or not the claims are directed to a patent ineligible concept. So those are defined as a law of nature, a natural phenomenon, or an abstract idea. So here again, the answer was yes, and specifically the court found that the claims were directed to an abstract idea of a template set of specifications that can be tailored for final production of a personalized product to fit a user's constraints. So answering yes to that question, the court then progressed to the second step of Alice here, which the court has to consider whether the elements of the claims, whether there are additional elements which transform the nature of the claim into certain patent eligible subject matter. So here the court found that the claims did not contain this inventive concept because they merely recited ordinary computers and networking functions such as collecting information for display, a specific display on a user's screen, but that these claims did not, the claims really just required ordinary computer and networking functions such as receiving, combining, translating, and transmitting, and of course displaying a video or content, but that there was no real concrete or technical improvement in the claimed computer or network functionality. So ultimately here, the Federal Circuit did affirm the district court, did reverse the district court's decision and found that the GoTV patents were ineligible under Section 101. And I think really just the practical pointers here, it's well known that claims directed to, ordinary computer and networking functions just in their ordinary capacity do not transform patent ineligible subject matter into a patent eligibility for purposes of Section 101. So just for, practitioners, it's important to not merely just claim the ordinary features of these technologies like computers and networks, but to transform into something more and to recite specific improvements, whether it's structures, algorithms, or certain data structures, to show that those computers and networks do more than just their ordinary perform in their ordinary capacities.
Our next case is another patent case, Envirotech v. Safe Foods. Envirotech has a patent directed to treating poultry with a certain acid to increase its weight during processing, which sounds a little bit like to me like a scam to sell the product for more money than it's worth. But they have a patent on it regardless. Claim 1 recites setting the pH of the acid water solution to a range of about 7.6 to about 10. And during prosecution, the lower boundary here was amended from about 7.3 to about 7.6 because there was some prior art that that show the pH at 7, which the examiner found to be too close to about 7.3, but I guess not too close to about 7.6. The district court found that the asserted claims were indefinite because of the about term, and Envirotech appealed. The Federal Circuit affirmed. About, in this context at least, made the claims indefinite. Um, there's a lot of precedent that says about can be okay to avoid a strict boundary, but you have to have a way of ascertaining what the boundary actually means. Um, Here, the patentee had some problems. One was that the specification ads showed several experiments that indicated about means, a plus or minus 0.3. But then one experiment showed that the deviation was a little bit higher and went up to 0.5, which undermined the claim in litigation that about meant 0.3 range. This was compounded by the fact that there was an amendment to avoid prior art at the pH of 7.0, which just added to the need for clarity on what about 7.6 meant. Um, so the takeaway here is that you can use about and approximately to give your claims a little bit of a broader scope, but you need to put some sort of facts in there to give them a hook. Um, and you especially run into trouble if there are inconsistencies in the specification about what the range might mean. So as a practical takeaway, if you are prosecuting patents, um, I, as a litigator, appreciate certainty, and I would encourage you to, if you say about 7.6 and you mean the range is 0.3, why don't you just say 7.3? Or if you really want your independent claim to have that wiggle room, put in a dependent claim that takes out the abouts. And that way you don't run into these indefiniteness type problems. At least your dependent claim would survive. And in litigation, if you don't have about in your claim, the litigators can always assert that via the doctrine of equivalence.
Right. Another patent case here, more mechanical in nature, but this is the Graham versus Deere and Company case. So Richard Graham owns U.S. patent number 6202395. And this covers an apparatus for maintaining the header of a crop harvester at a desired height above the soil, as the harvester traverses the field. And the 395 patent is exclusively licensed to Reaper Solutions, and Reaper filed a lawsuit in 2014 asserting that certain Deere and Company header sensory kits infringed upon the 395 patent. There was some inter-parties review, a challenge by Deere Company, and then subsequent appellate review. And after both of those things, only independent Claim 12 of the 395 patent remained asserted in the district court litigation. And so at the district court, during the claim construction, and this was in the district court for the Southern District of Iowa, the dispute specifically focused on a means plus function limitation, which I'll just refer to as the control means. But as you can see on the slide here, the specific limitation recites a control means for raising or lowering the header in accordance with said first signal and maintaining the header at a designated height above the soil. So there was no dispute here between the parties that this limitation, in fact, was a means plus function claim limitation, and that section 112F of the Patent Act would apply. There was also no dispute as to the claimed function. Both parties agreed that the claimed function here is to raise and lower the header to a specific designated height above the soil as the harvester traverses the field. Where there was a dispute was whether or not the specification provided a corresponding structure for this means plus function claim limitation with specific definiteness. So in the specification, the corresponding structure corresponding structure included a controller interface, a head controller, and a hydraulic control system. And the specification interestingly noted that the head controller, that specific structure, is conventional in design, and in a specific embodiment even stated that it's as incorporated in a Deere combine. So Deere meaning the same party in the dispute here. And upon factual, evidence and discovery, Deere showed that through expert testimony that at the time of this application, the priority date in 1997, there were only three commercially available head controllers that were used by Deere and Company, and these were all called dial-o-matic versions 1, 2, and 3, as you can see on the slide. So the district court right away disqualified version number 1 of the dial-o-matic as a corresponding structure for this means plus function limitation because it could not laterally move the header. And that's important because the specification here described that the header controller could also perform the additional function of lateral movement, not just movement up and down above the soil. So the district court disqualified dial-o-matic version number 1. And with respect to versions number 2 and 3 that Deere used in its combines, the district court said that both of these structures use microprocessors, but because the specification of Graham's patent did not disclose an algorithm by which these processors could operate, that they were not sufficient corresponding structures for purpose of this means plus function limitation. And ultimately, the district court found that this claim limitation was indefinite under section 112F and that the claims were invalid. And this is just a diagram of the actual technology here. So on the left-hand side, we have figures 1 and 2 of the 395 patent. So you can see the header, I believe the header controller is number 20 on the diagram. And then on the right-hand side is just a diagram of Deere's dial-o-matic. I believe it was called header height control. So they do appear somewhat similar. So again, the legal issue was pretty specific. It's whether a disclosed structure, so in our case here, whether the dial-o-matic version number 1 should be excluded as a corresponding structure for purposes of section 112F if it is capable of performing the claimed function, so raising and lowering the header to a desired height above the soil, but it is incapable of performing another additional distinct function, which is merely mentioned in the specification. So this here would be the lateral movement of the header. And ultimately, the Federal Circuit held that no, that structure shouldn't be discluded and that the district court erred in doing that here. That because the dial-o-matic version 1 could perform that specific function as claimed, that was all that was needed. And essentially, the microprocessor argument kind of failed because the dial-o-matic version 1 was the older version, and it operates through circuitry with diodes, switches, and circuits, so not a microprocessor. So the fact that the specification didn't disclose an algorithm didn't really mean anything here. So again, the Federal Circuit reversed the district court's indefinite determination and remanded for further proceedings. And again, just for practitioners here, I think the main takeaway is just to anchor your means plus function limitations with specific exemplary structures in the specification and call out that they can perform the claimed functions, and whether or not they perform additional functions really doesn't matter in the grand scheme of things for section 112F.
Moving on, hopefully I can address this slide very quickly. These are two somewhat boring cases, but they have important procedural things for people who practice in these areas. The first one is Ascendis Pharma v. BioMarin Farm. The issue there was that there was a district court litigation and a concurrent ITC proceeding, International Trade Commission. And if you file within a certain period of time, you can have the district court proceeding stayed in favor of the ITC proceeding. The issue here was that the party in this case missed its deadline, but it voluntarily dismissed the case without prejudice and refiled it just so that they could try to argue, oh, now we are within our deadline of filing the second case. Um, the Federal Circuit said, not so fast. We're not going to play games like that here. Um, your time starts from when the first action was filed. So the stay was denied in that case. And if anyone finds themselves in that situation, that little trick will not work. The second case is Iron Source v. Digital Turbine. And this was an appeal from a PTAB case where they tried to amend the claims during an inter partes review, um, and the um, newer narrowed claims, there was no allegation of infringement regarding them, so that when it went to appeal, um, the Federal Circuit looked at Article 3 standing and said there's no live dispute anymore. So we cannot review this case. So just keep it in mind if you work in the PTAB and with appeals to the Federal Circuit, um, your standing to file the petition at the PTAB is not necessarily the same as your standing to file an appeal. So you got to pay attention to both issues.
Thanks, Keith. All right. Oh, another poll just popped up, so feel free to answer that if you need credit. So I am cognizant of the time, so I'll move through this one and the next one a bit quicker. But this is another patent case, Fortress Iron versus Digger. Fortress Iron owns and sells and designs railing and fencing products used in construction for outdoor living spaces. It specifically works with two Chinese companies to manufacture its products. And the Fortress owner, named Matthew Sherstad, had an idea for a vertical cable railing panel, which could be purchased pre-assembled so that it would be easier. You wouldn't have to assemble on site. It could just come pre-assembled and you could apply it right when you get to your site or location of work. And another Fortress employee named Kevin Burt actually sketched a design for Sherstad's idea. And then they worked with one of the manufacturing companies, one of the Chinese manufacturing companies, and in particular, two employees of that company, Huang and Lin, to build and produce a prototype. And the prototype at first, it had several problems with the cables, which would rotate up during tensioning. And the Chinese manufacturing company employees, Huang and Lin, actually suggested changes to the design, which were incorporated in the final designs that were later applied for and obtained patents on by Fortress. And these are the 707 and the 209 patents. Interestingly, both patents, though, only named Sherstad and Burt, the two Fortress employees, as co-inventors, and there was no mention of either Huang or Lin. An important factor for later is that Huang later left the manufacturing company in 2016 and didn't provide any of his contact information to the company or Fortress. So that's a very important factor. And just to shed some light, this is, I guess, a vertical cable railing that Fortress sells. This was online at their website. And then here's just a corresponding figure from the 707 patent showing that design. So in January of 2021, Fortress sued Digger for infringement of both of these patents. During discovery, during the course of litigation, Digger uncovered that both Huang and Lin contributed to the invention and therefore should be named as co-inventors. Fortress was able to locate Lin successfully and add him as an inventor to the patent under the statutory framework of 35 USC section 256A. But as I mentioned previously, Huang did not provide any of his contact information to Fortress or the former employee, and therefore could not be located for purposes of adding inventorship here with respect to the patents. So Fortress moved for partial summary judgment to correct inventorship under section 256B, which I'll show on the next slide. This is the statutory framework. It basically provides for judicial correction of an invalid patent, or I'm sorry, not an invalid patent, an erroneous inventorship with respect to a patent, which could lead to invalidity. But here, basically, as you can see, it requires a notice and an opportunity for a hearing to all concerned parties. Ultimately, the district court denied Fortress's motion here for judicial correction of the inventorship and granted Digger's motion for summary judgment, finding both patents invalid for incorrectly admitting inventor Huang. So the legal issue is really straightforward. It's just whether an agreed upon admitted inventor, so in our situation, this is Huang, whether that person is a party concerned under Section 256B, who therefore must receive notice and an opportunity to be heard before judicial correction of inventorship. And the plain and simple holding was that yes, co-inventor here, as Huang was proven, he was certainly a party concerned. And the court even cited to the fact that inventorship carries legal, financial, and ownership consequences, such that an inventor should always have a right to contest and should always be given these, procedural notice and an opportunity to be heard before certain corrections are made with respect to inventorship of the patent. And I won't get into the nuances of Fortress's arguments that they tried to convince the Federal Circuit with here, but ultimately they were to no avail. I think the law is pretty clear that a co-inventor is certainly a party concerned for purposes of this statute. And just a minor practical pointer is just to always document inventorship, especially during international collaborations where you're maybe not as hands on deck with all parties involved, but it's very important in this case proved the fact that if you can't locate an inventor and add them, your patent is going to be invalid. So, there's some pretty serious consequences associated with this type of thing.
All right, one more patent case I think we have on the list. I'll try to get through this one quickly. It's Teva versus Eli Lilly. Teva has patents claiming methods of using certain antibodies to treat headache. Um, it previously had composition patents on those antibodies, but they got invalidated. Um, Teva's patents cover the Ajovy product. Eli Lilly sells Emgality. Um, and in the lawsuit here, Eli Lilly asserted written description and enablement defenses because the specification only discloses one antibody in the genus, but says that other antibodies could work for this purpose, and they and the methods of making them were known in the art. The case went to the jury. Oh, before we get there, in IPRs over the composition patents, Lilly took the position that the antibodies themselves were well known, replete in the prior art, and that humanizing them was well established and routine. That'll become important on the next slide. The case went to the jury, which found a willful infringement and rejected the written description and enablement defenses, but the district court basically went the other way, granted judgment as a matter of law of invalidity on both written description and enablement grounds. Teva appealed, which we'll see on the next slide. So the issue is whether claims regarding a method of using a known genus of antibodies for a new therapeutic purpose, what level of disclosure do you have to give in the specification for that genus and the species within that genus? There was Supreme Court case a couple of years ago, Amgen v. Sanofi, and a subsequent Federal Circuit case, Baxalta, that talked about that standard in the context of composition patents, where you're actually claiming the genus. And it set some standards for what you have to disclose there to sufficiently enable and show written description of the full genus. The Federal Circuit here, though, reversed because the claims are not to the antibodies. They're claiming using those antibodies to treat a new condition. And so Amgen and Baxalta don't apply. Interestingly, the Federal Circuit used Eli Lilly's statements against them. They pointed to those statements from the IPRs about well-known, replete in the prior art, and said, all right, well, if that's the case, then you don't really need to describe them in any detail in the specification. Everyone knows what they are. Your invention here in these claims is using those known things for a new purpose. So the disclosure in the patent does not have to be super significant for those known um, species within the genus. That said, you still have to disclose something. Teva did that. They disclosed one species, and they disclosed the genus more generally. And the Federal Circuit said that that's enough. Um, so, um, for those of you drafting method of use patents, this is the standard to follow. You got to obviously put something in there, but it doesn't have to go full into the deep end like you would if you were claiming the composition itself.
All right. Turning to our last, or no, second to last, but I don't know if we'll have time for our trade secret case. This is a big copyright case from the Supreme Court of this past year, Cox Communications versus Sony. And basically, the gist is that Cox is a major internet service provider with over 6 million subscribers. And Sony, as many of you I'm sure know, is a well-known major music copyright owner. And Sony hired Mark Monitor, which is an American software company that develops software specifically designed to protect corporate brands from internet counterfeiting, fraud, piracy, and cyber squatting. And it hired Mark Monitor to track online infringement across the internet. On behalf of Sony, Mark Monitor actually sent Cox a total of 163,148 copyright infringement notices over a 2-year period, basically identifying certain subscriber IP addresses associated with copyright infringement. And so Sony sued Cox for secondary copyright liability premised on the subscriber's direct copyright infringement. The district court found Cox liable on both theories of contributory infringement as well as vicarious infringement and found this infringement to be willful. And as you can see, awarded damages to a tune of 1 billion. So pretty large damage award there. The Fourth Circuit affirmed with respect to contributory copyright liability, but reversed on the grounds of vicarious liability and vacated and remanded for damages reassessment on the contributory theory alone. The Supreme Court granted Cox's petition for cert on contributory liability only. And I thought this was a really neat diagram, which just kind of shows the gravity of the situation between, the copyright owners on the right, especially in the music industry, and service providers on the left. So this conflicting context here. The legal issue really just boils down to whether or not infringement alone, I'm sorry, knowledge of infringement alone is sufficient for purposes of liability on a contributory infringement theory. So here, the main issue is really whether obviously Cox was aware of certain infringers using its services to infringe copyrights, but it continued to provide that service to them. So whether or not that pure knowledge alone, absent anything else, was sufficient for purposes of infringement liability here. And the answer was no. Knowledge is not complicity. Induced infringement on its own requires an affirmative intent that the product or service be used to infringe, which was obviously lacking here. And contributory infringement, interestingly, requires that the product or service that is being given here, so Cox's internet service, it is used for infringement and is specifically made or adapted to be used for infringement, and it has no other non-infringing purposes. Obviously, here it's pretty apparent that providing internet service is not just solely used to infringe copyrights, especially those of Sony. So that the knowledge alone that its subscribers were, viewing or uploading infringing content wasn't enough to support a finding of contributory infringement. But I will say the concurrence of the Supreme Court decision by Justice Sotomayor, she also opened up the idea of a third theory of liability, which is common law aiding and abetting. Ultimately, this didn't carry the day, but it's just something worth noting in the future that contributory liability, or if that alone is not sufficient, then you could also sue on a theory of aiding and abetting under the common law. So that's a quick coverage of that case. I know we're close to time, Keith.
Yeah, it looks like we just hit 10 o'clock.
Yeah.
I won't keep everyone past the hour. We had two more cases, one more copyright case, one more trade secret case. I encourage you to read the slides. They're both a little bit interesting. If you have questions about them, feel free to reach out to me. You got my email address right there. I can give you some pointers, um, based on those slides if you need them. But otherwise, I think that's the end of our presentation, and that's the end of our Managed Training Academy sessions for the year. We take the summer off to let everyone enjoy the nice weather. We'll be back in the fall. Thank you all for attending, and feel free to reach out to either of us if you have any follow-up questions.
Thank you.